Welcome to the monthly Truck Stop webinar. The Truck Stops are presented by the Motor Carriers Insurance Education Foundation on the second Thursday of each month at 2 p.m. Eastern Standard Time. These webinars are open to members of the Motor Carriers Insurance Education Foundation. These webinars are presented as industry updates and informational purposes only and do not qualify for state CE credit. If you're seeking state CE credit, please contact or look at our website, and you'll see that we do offer 12 hours of CE each year to meet your state insurance requirements for updating your CE. If you have any questions, please type them in the chat window. They will be answered as time allows or responded to after the webinar via email. If you experience any audio problems, please give us a call or take a note in the chat window. Give us a call at 800-741-4840. We'll attempt to correct the problems as soon as possible. I've asked Bridgette to come back again with us today, our friendly lawyer out of Orlando, who has added a lot of stuff. I've used her before, and she has helped us to talk about structuring our companies to be protected from verdicts and things like that. But also, we're seeing a lot of movement in the industry as mergers and acquisitions, some of them forced by the higher insurance costs, some of them forced by bad claims, and some of them forced now since there's a slight downturn in the shipping market, given all the politics and other things going on, that companies are looking at that, particularly smaller motor carriers, and how it's the best way to do it. Bridgette, welcome.
Tommy, thank you so much. It's always a pleasure to be here.
Well, it is you, and you're one that we rely on a lot to keep us informed of what's going on, and I look forward to this program. This is an area that you have a lot of knowledge in, so I'm just going to sit back and listen to you. As always, if I see something coming up that I want to question you in more depth, we'll go from there. But if you'll go ahead and just talk about things we are here and tell us where you're going to go with it, and we'll go from there.
Well, sure. You know, I thought this was a nice topic to segue into the new year, 2020. You know, we saw a lot of volatility in 2019. Dami, as you mentioned, with the nuclear verdicts that were trending, unfortunately, against many motor carrier companies and many companies that had manufacturing or shipping as well as motor carrier operations tied to it. We saw a lot of transitions too with companies closing in the industry. We saw that also because of a decline in the demand of freight, the increase in the cost of operating, including the cost of insurance, the cost to maintain equipment. And then we also saw that because many of our friends and clients in this industry are family-run businesses. And so it's oftentimes many generations that will carry the torch, and then sometimes there's just no one to continue carrying the torch any longer, so that the companies decide to sell their business or their assets. So with a lot of that change happening in the industry, I thought it was really important just to kind of give a little bit of an insight of what's going on. I know many of our audience members see this, they're insured, their clients contact them when they're looking at either acquiring additional assets, acquiring new companies, extending operations to either open new terminals or start maybe new authorities. There's a lot of just different scenarios that we're seeing out there in terms of both growth and then reduction in size of our clients and insured. So I kind of wanted just to go through from my perspective, my legal perspective, and give an insight of what happens when we get a call in our office and somebody's interested in either buying or selling a company. So there's a lot that goes into this, obviously, and then there's also the dynamics of, well, how big of an acquisition are we looking at here? Is it an asset purchase only? Or are we also looking to acquire the stock or the membership interest if it's a limited liability for a company, for example? and we're looking at, what's the purchase price. Sometimes we're seeing smaller scale acquisitions where we have maybe a 3-truck company that's being acquired, or maybe it's a 3-truck company that is being acquired not because the trucks are of any asset, but because the motor carrier authority that company holds has value. So we're seeing a market out there for that target.
Bridgette, in this area here, now you bring up a point here I was going to ask. An asset purchase obviously is when you just take the assets out, but in those cases it'd be tough to keep the authority or the DOT number or the DOT history if it's an assets purchase, would it not?
Yes, so that's one of the considerations when a client calls and says, I want to acquire a company. That, the first question are you looking to acquire the assets because you want to add growth to your fleet? Maybe it's a set of trucks or trailers, or maybe it's a new terminal, or are you looking to acquire the asset because you want the actual motor carrier authority that's associated with that company? And we have to understand, what's the reason behind the intent to purchase. And what we're seeing is if the intent to purchase is in order to acquire the operating authority of that motor carrier, it's not really going to do them much good just to do an asset purchase agreement. And the reason why is because the FMCSA will not transfer a DOT number to a new federal identification number associated with a company. In other words, you can't just go and start a new company, get a brand new FEIN with that company, and then transfer the DOT authority into the FEIN. As ideal as that situation would be for a buyer, unfortunately, the DOT authority is tied to the federal identification number for that particular company. So if a prospective buyer, wants to buy a motor carrier company and acquire the actual motor carrier authority, it's going to have to consider, is it worth it to take on then what is a stock purchase or membership purchase of the company.
Let's dumb it down a little bit here. What we're saying here, assets could include the customer list and the customer's goodwill, but you cannot buy that. And that's also a big important part for the insurance, because everything you say about the federal government regulations tied to the FIN number, the legal entity's name and number, that's also what the insurance is tied to. So if you do an asset purchase, then the transfer of the insurance into that or take advantage of the previous good insurance history of an asset purchase would be hard to roll over. Or a stock purchase, that obviously would be easier. Obviously, management and all should be divulged, so make sure everything's clean. But then you're going to talk about later, because I've reviewed your slides, let's talk about the stock purchase. Now you might buy some liabilities that you hadn't thought about. But that's just trying to dummy it down. So go ahead. I didn't mean to interrupt you, but I wanted to just kind of clear that up.
No, that's great, Tommy. So that's right. And there's risk exposures that we're going to talk about if you do a stock purchase acquisition, or you actually purchase the company itself, not just the assets. So you have to weigh what is the potential risk exposures in this company. And we're going to talk about the due diligence side of what goes into purchasing a company and what documents you want to look for. And you can certainly undertake it, and I do obviously recommend a full in-depth due diligence with an asset purchase agreement. But with the stock purchase agreement, you're accepting the liabilities. Anything that's in that company is going to follow the new owner of that company when it's acquired. And so certainly there's strategies that we can look at in an acquisition about how to try to limit those liability exposures, of course, understanding what they are before you purchase them. But this is just kind of taking the big picture look at, are we talking about an asset purchase, trucks, trailers, desks, terminals, things like that, versus the stock purchase, which is the actual either the stock or the membership units where you're taking on the whole company.
So bottom line is, if they're interested in growth and acquiring vehicles and hopefully drivers and that kind of history and customer list, then an asset purchase might work. But if you're looking at their past history, CSA scores, authority, insurance, then that probably would not work, is where we're going from here. So we'll go. I'll see you on the next slide. I'll be quiet.
Right. No, but that, yeah, and that's, just generally speaking, and there's a
Right.
lot of
Overview. Right.
discussion that will go into, okay, if we're going to buy the assets, or the driver's going to come with you, are there any liens on the equipment that need to be taken in consideration? And of course, the big one in the industry is the insurance relationship that the company has, and will the insurance company follow the new owners if it's a stock acquisition, and even if it's not a stock acquisition, and it's or if it's an asset acquisition, and if it's a stock acquisition, the same questions need to be had, that the insurance company is going to continue to insure that entity and the risks, even though it's under now new ownership and or possibly management. So that's that kind of sets the stage for what we're going to be talking about. And just to give some further insight into some of the issues that we look at when we consider an acquisition of a company, as we look to see internally, is there anything, if we're the company, for example, that's selling either the stock or the company, are we looking at our own internal documents? Do we have shareholder or buy-sell agreements that talk about what happens when there's a buyer that's interested in owning or taking over the company, or maybe it's just a percentage of the company? So we're going to look at those documents. Or is there trust? A lot of times companies have set up trusts to be owners of that entity, and the trustees have discretion on how the disposition of the assets will take place in the event of not just the company winding down, but also with respect to the sale of the business or the assets. So there's internal documents that are roadmaps, if you will, that our clients are going to need to look at when considering selling their business. And of course, obviously wanting to do so, because in whatever contract ultimately gets drafted, your counsel should be drafting an extensive set of representation and warranties. If you're the seller, disclosing that any issue that could have a material adverse effect on the business, or any other document which might contractually limit the ability of the owners to sell the company, should be disclosed. So understanding what those internal documents are very important, so it doesn't end up in a legal battle after the fact.
You don't want those, I promise you. I've been in a couple of that stuff, so you got all the truth here, and I be prudent about it. There's certain things that are unknown, like as you just mentioned, the value of any outstanding claims or things like that. That could be in there, but that should not preclude the sale. It's just something that needs to be addressed, is what we're saying, what you're saying right now, right?
Yes, exactly. So, that's part of the due diligence when you're looking at an acquisition. On the buyer side, what you're going to want to do is you're going to want to, a couple things, enter into a non-disclosure agreement, confidentiality agreement with the prospective target. There's a lot of information that's going to ultimately be exchanged before any transaction is ultimately consummated. So the non-disclosure agreement is there to protect both parties, because both parties are going to be revealing sensitive financial information, or other information that they don't want the general public to receive. And that could include customer contracts, customer contacts, financial information about the businesses, as well as other resources or business strategy that really makes that company valuable. So there's a pretty exhaustive list of a due diligence that should go out. And now some of this information may not be applicable to the company, but that doesn't mean that it shouldn't be asked. The point is to gather as much information in that due diligence phase, so that the buyer that is can evaluate the risk exposure. And again, like I was mentioning earlier, this is really important in particular when you've got a stock purchase acquisition, because you're looking at taking on the liabilities of the company. So if the company has $1 million line of credit, you want to know, is that company within its financial covenant ratios, or is it in default, and is the bank about to execute and file a complaint for breach of the loan documents? So you want to make sure you gather all the financial information about the companies, what obligations they have to lenders, if they have outside lenders. You want to look at material contracts, which you want to look at not only customer contracts, but vendor contracts are really important. A lot of times there's different vendor contracts that obligate companies to a specific term of years. And so you want to be fully advised of what the obligations are for your prospective buyer, knowing what terms and conditions they're buying into with these vendor contracts. There's issues we talked, Tommy, you mentioned, management and employees. How is it that the transition is going to affect? If it's a stock acquisition, are the employees going to remain? What kind of benefit plans do you have for the employees? Do you have any pending litigation with any of the employees? Is the same management going to take over? Are you looking at entering into employment agreements, let's say with what will be the former owners, just in order to ensure continuity of the business operations? So,
there's also a part of non-compete, and also a part of the, in some states, don't they even have to, if they tend to lay a lot of people off after this, don't they have to even notify the states in some situations?
Well, and that's going to depend certainly on the jurisdiction and what choice of law or governing law is going to apply where the transaction is occurring. So there's a lot of consideration that goes into the transition of employees, or human capital, if you will. And obviously drivers are very important in this factoring of the type of acquisition you're looking at. So again, it really depends on, you have to understand what's the purpose of the acquisition. Is it just to have an asset-based fleet and you're not worried about getting the equipment and the drivers, that those will eventually follow, and you need that? Really what you need is just the authority and a low cost of insurance? Or is it that you have a new lane of traffic, a new customer contract that's bringing a lot of volume into your business, and therefore you need to acquire the assets and the drivers of the company in order to sustain and fulfill the obligations under this new customer contract? So you have to, consider, okay, what's the purpose behind it? And then of course there's business decisions behind it, and making sure that it's a financially sound decision to grow when you grow with additional assets and employees, because you're taking on additional overhead. And one of the things that we saw in 2019 was the companies not being able to sustain themselves, because they did acquire new assets, new trucks, new drivers, and ultimately they were losing money on either those truck leases or those truck finance agreements, and they didn't have business to sustain it. So it's a very delicate important decision to make when you're looking at your reasons for growth. Hence why these categories are important, and you weigh in on that acquisition.
Right, I agree. This. All right, go ahead. I'm sorry, I didn't mean to.
So no, it's just again, this is just they're all laying out all the different dynamics. You may have situations I mentioned where you have a company that has real estate. Is the real estate getting included as part of the sale? Is there any issues with any liens or with pendants on the properties that you have to evaluate? There's doing a very careful evaluation of pending litigation, as well as, let's say, if there's been prior IRS audits or DOT audits that the company has been faced with. Have they been successful in those audits? Have those issues been resolved? Have the statute of limitations passed on any potential claims or threatened litigation? A lot of time can really be focused on this particular category and making sure that a company is not stepping into a landmine. Even if an accident happens and there's no lawsuit, doesn't mean that if you're still within the statute of limitations that you're ultimately going to see that claim come down the pipeline. And if there is a claim that could result in a lawsuit and you are making that decision to buy the company, then you have to consider, has an adjuster been assigned? Has defense counsel been assigned? Has there been an evaluation of what the risk is in this claim? Is there a coverage opinion? Do we have any concerns? For example, Tommy, we talk about where an insurance company might have a defense to coverage, even though under the public liability endorsement they'll defend. Do they have a right to seek indemnity back against the insured if they do proceed forward with a defense?
Right.
So there's a lot of issues and dynamics that, again, go back into that stock acquisition. If we're looking at that, if we're looking at just an asset acquisition, and we'll get to this if we have time, there may be other risk exposures such as successor liability that we'll need to take into consideration. That could be one potential risk that could follow the new company. So we can evaluate that, but the main consideration is just knowing what is out there.
Full disclosure.
Right,
That's
right.
what you're saying. That's the important part.
Exactly. Intellectual property, this is really, I think, becoming an interesting issue where a lot of motor carrier companies are wanting to protect their name, protect their brand, and a lot of companies have not done anything to protect their business name or their logo. So you look, is there any intellectual property rights tied to that? Or if you do take on a name and somebody's already registered it with the U.S. Patent Office, and the question is, are you infringing on somebody else's patent rights? So, not a patent attorney, and whenever that happens, I have a good friend who helps me with those issues, but we flag it as an area to identify if there's a risk that we might be infringing on somebody else's intellectual property rights. And then, of course, to the regulatory matters. And then here, Tommy, where we talked about where is the company at in terms of its operation, and is it under threshold on their basic categories? Have they been through an audit, or are they unrated at this point? Taking an inside look at what their safety score is, at least from an FMCSA perspective, to understand, are they at risk for potentially an intervention for the FMCSA or the Department of Transportation to come in and evaluate them. So we want to understand from the FMCSA's perspective, are there any concerns? Are there any risk issues? And of course, that's just one regulatory body. We're not just only looking at DOT, we're looking at EEOC, we're looking at OSHA claims. So we want the full gamut of any potential regulatory body that has the control over the potential target's acquisition for any claims or risks that could be identified.
Bridgette, there's one that we often don't think about that ends up in case head on, and this is an NCCI and their experience mod situation, where even though you have a change in ownership, doesn't mean that you're going to get a new mod. In fact, there is rules out there that depending on the percentage and the management changes, the old mod carries over to the new entity depending on who's the controlling entity. So that's also one thing that I know a client that got caught by not reviewing those things, thinking that their insurance, work comp insurance would go down or at least go back to one because the new ownership that came back said, no, it's going to be the same old mod here, and it increased their cost about 20% in comp without them realizing it. So that's another area. So you got to check everything here. You can't go in this thing without your eyes completely open.
That's right, Tommy. And, it's in that particular issue, it's obviously, not uncommon because I've seen the exact same issue come up in my practice as well. And it's difficult and costly to try to challenge any determinations that you have from the NCCI. So it's something you want to get ahead of. And know, if you're going to, in my case, if it was twice the amount of premium that we were looking at from our client, and it took a long time before that rating eventually dropped off. So it's definitely an issue that's out there. So if it's not disclosed and you have your list of schedules and ultimately your contract for purchase, and it comes back that now the premium is a quarter more or twice as much as it was before, you at least want to make sure that you've asked for that and you've got the seller signing off that everything's been disclosed, so you have some contractual recourse against the seller for not disclosing that risk to you.
And there's also ways to get around that, depending on, you got to read the regs real closely to determine if it can or can't be done. That's another area. But anyway, go ahead, Bridgette. I just want to bring that up because that is something that's insurance related that clearly gets overlooked sometimes.
It does, and it's like with each of these categories here, I mean, we're just really scratching the surface, if you will, of the potential areas of due diligence and issues to be explored, which, from a client perspective, from your insured's perspective, is and can be a struggle if your purchase amount on your potential acquisition is, maybe $100,000 or less. They struggle with paying the cost of attorney's fees to go through this exhaustive due diligence with what's considered a smaller acquisition. And so the takeaway there is, it doesn't matter if it's $1,000 acquisition of a potential target, these risk exposures are going to remain. And if you don't understand what it is that you're buying, you're going to be paying a lot more than $1,000 for the authority or for the company. So, to the audience, that's something to think about, is regardless of the size and scope of the acquisition, to at least be aware and say to your insureds that is just critical that you get qualified counsel to have and oversee this process, so that they're not buying something or going into something without knowing the full exposure.
Got it. Let's go ahead and move on then, okay?
All right. Quickly, we didn't touch tax matters, but tax matters is one of these things where the IRS is relentless. And if there's potential risk exposures out there with the IRS, obviously you want to get qualified tax counsel because there are claims that the IRS can bring for successor liability, even if it is a stock acquisition and it's a completely new entity. They're going to be looking at, all right, are you using the same principal place of business? Are you in the same line of business? Do you have the same employees? Do you have the same management? Do you have the same or similar officers? And so even though it may be on paper a brand new company and a brand new FEIN number, it doesn't mean that it's just going to be an easy walk away for you. So let's talk a little bit about some of the considerations from the FMCSA's perspective. So if a potential client comes to me and says that they want to just acquire the MC number of a company, okay, we can do that. We can transfer the MC number out of a particular entity and do either a name change or a change of ownership filing with the Federal Motor Carrier Safety Administration.
Bridgette,
and that,
I
yes.
want to interrupt this then because I want to make sure where we're talking about this. MC number is authority to haul. Most of the insurance, though, that requires the insurance filing, that requires the 91X. But the DOT number is where all the on-road activity CSA is tied to.
Right.
Can you transfer the DOT number to, or just the MC number with a change of ownership?
No, you cannot transfer a DOT number. So the DOT number is tied to the federal identification number of the company or the individual that has that authority.
So the MC number could be an asset that somebody could buy, and that would only be showing the history of the insurance and the history of that, but would not tie to the DOT number, which would be the on-road activities. You would have to have a stock purchase on that, and that's where the insurance company. So if you ever come up with a situation where there's everybody listening to us, where there's this conflict here, because Bridgette, you remember you asked me a number of years ago, or maybe even shorter than that, I've got people who want to buy MC numbers. How does that affect insurance? And as long as the insurance is tied to the legal entity and to the DOT number, that's going to be difficult to get through to an insurance company without full divulging. Now, it can happen. There's reasons to happen. Obviously, when authority was hard to get back in the days when my father transferred from pickles to cucumbers, that most people hear, that cucumber hauling authority was worth a lot of dollars because it cost them a lot of dollars to do. Now it's not too. Now there's no experience and there's no advantage to that since it's been deregulated, and so it's easier to get a new MC number and a new DOT number. So that creates a situation here. But go ahead. I just want to make sure we understood that both of them are tied together. You can only transfer one of them.
Yeah, exactly. So if, for example, you want to transfer an MC tied to a broker authority, you can file an application with the Federal Motor Carrier Safety Administration and you can transfer that MC authority, but you're still going to have a separate DOT number for that operation, and you're going to have a $75,000 surety bond in place and a BOC3 file in place, because you're not transferring the DOT number. You're only transferring a part, if you will, of the authority. So the minimum financial security requirements for a broker are obviously going to come into play when you transfer that authority over. For a motor carrier company, you can also transfer a MC number, but if you do not have a existing, well, let's say this, if you don't acquire the company with the DOT number, you're going to have to get a DOT number because that is going to be specific to that company. In other words, you can't transfer a DOT number. You can only transfer the MC. And if you acquire a new DOT number, you're going to be considered a new entrant. So you're not going to get the benefit of that DOT history that was previously assigned to whatever MC number that you are acquiring.
Yes, but there is a point here. A lot of the insurance, this is somebody first getting in business, goes back and looks at time in business only to how long they've had an MC number with a 91X filed in their name. That would be an anomaly that could happen where it's a new entry, but since they bought somebody's MC number, it might show the insurance history longer than actually the operating history.
Right. So that history is going to be tied from and this is from an FMCSA perspective.
Right.
So from the FMCSA's perspective, they don't care about the history on the old DOT number. What they're going to care about is what is the history, if any, on the new DOT number that's now connected with the MC authority. So unfortunately, you can't just transfer that MC number with an old age DOT and then expect the FMCSA to port all that great history into that new MC number, which I know, would be ideal, obviously, for so many.
Make your asset worth more, obviously.
Yes. I mean, it would be great if DOT numbers were portable because then you could just say, oh, well, we're not going to buy the company. We're just going to buy the DOT number. And then we don't have to deal with all the potential risk exposures of buying a new company.
But I point that out because this is an anomaly here. So we can go ahead with this, understand this part of it. So let's go how you want to finish the rest of this, Bridgette. I didn't mean to interrupt.
Right. Well, so I mean, and the concern is that you have the FMCSA taking, careful look at companies and making sure that companies aren't just opening and closing their doors to avoid fines from the FMCSA or out of service orders, and then they just set up and reorganize into a new entity, and that's where we see the FMCSA issuing the out of service orders and request to consolidate Department of Transportation authorities. So in other words, what happens out there for those people that are trying to avoid the enforcement mechanisms of the FMCSA, they say, oh, well, I'm just going to go use my brother or my daughter or whatever the case may be, or my friend, and I'm going to open up a new company, and I'm going to try to just start from scratch here to avoid the fact that maybe their former company was involved in a fatality and they're out of service or whatever the case may be. So you have to consider that you're not going to be raising any flags with the FMCSA, because I'll tell you, challenging the administrative agency actions from the FMCSA is an uphill battle. The government, they do their homework when they bring those agency actions, and so if you're going to be starting a new company or you're going to be acquiring a company, you want to make sure you've done your due diligence so that you're not faced with an agency order to consolidate your DOT number, because if that happens, and let's say you've got these other DOT numbers that get consolidated with that entity, then what that means is whatever agency action was pending against that other entity is now going to be enforced against the new entity. So if it was an out of service order, if it was $100,000 penalty, whatever the case may be, that is going to be the consequence and the reality of this new company. And until those issues get resolved, whether it's taking corrective action and filing a safety improvement plan with the FMCSA or paying that fine, unfortunately that DOT history then is going to haunt that company. So there's a lot to consider here, but the point being is that you have to look and really dig deep behind these operations to ensure that you're not buying a negative history or opening yourself up to potential success or liability when you're acquiring a new motor carrier operation. And I'm sure, Tommy, as you've seen with respect to the insureds, when they have those agency actions where they're consolidating DOT numbers, it's going to just make it incredibly difficult then to either get a renewal on insurance or get insurance because that negative DOT history is now associated with that company.
Yeah, this is a thing, and I don't see many of that for that very reason. They go in and think they can hide some past history or buy somebody else's history rolled to them. And the insurance industry today, with everything that we have from CAB to carrier software to people like yourselves and knowing what it is, it's just impossible to do that. So my point here is anybody who's listening to us and the insured comes and says, can I do this and can I do that? Yes, there's advantage of buying it for, and if you need to expand your equipment, there's advantage to buy the buildings and things like that. To buy the stock, though, to get advantage of the rest of this kind of stuff is going to be hard to sort out and to justify eventually. But anyway, let's go ahead. We're going to run out of time if we don't watch it. Go ahead.
Yeah, that's all right. Well, and and some of these, I'm just some of these slides, I don't have a lot of this these agency orders or opinions, but the authority is out there. So if anybody wants to contact me to get a copy of what these agency opinions look like, I'd be happy to share that information. It's available on the FMCSA's website. So, all right, so I know we're going to kind of breeze through the other risk exposures that we want to take into consideration when we're looking at an acquisition. Again, you have to look at, okay, even if it's an asset based purchase, are there any skeletons in the closet of this company that are going to come out and try to follow us after we acquire the assets, and certainly if we acquire the stock. So these are kind of the big things here that we can look at. Tommy, like we talked about, is the MAP 21 that's been in place, but there's still that operational business out there that will broker loads through their motor carrier authority without separate grant of registration, because they get it in through their asset-based company and then they tender it to their broker. I mean, an example would be you have certain big shippers that are out there, the Ciscos of the world, that will send out separate contracts to their asset-based motor carriers. And so they get put in a separate group because they have that asset fleet and they really want that work, but then they tender that shipment not to one of their own tractors, but they tender it to their own, let's say, internal broker department, their logistics company that they have, and then that logistics company arranges the transportation. We'll just pick on Cisco, and we'll then arrange to have that shipment transported by a third-party motor carrier, and now you're in violation of MAP 21. So what's the concern with this scenario when you're selling a company or you're buying a company, is you want to understand if you're acquiring a company and it looks like they have a really lucrative contract with a customer, you want to know, well, do they have sufficient capacity to actually manage the work that's under that contract? And if not, how are they managing it? Are they putting it in a position where they're violating MAP 21, which, as we know, if there's somebody that then endorses that violation, that liability can then follow to the person who's knowingly accepting these brokered loads without having the requisite authority. So there's that issue to consider. Sorry,
I was reminding somebody I actually had a case like this I got involved with, and the plaintiff's attorney brought up civil conspiracy because of violation of MAP 21, bringing in as you said, the motor carrier who allowed someone other than the motor carrier to haul the load without the brokerage authority. And so that's the only way they would be liable in that case, is because of the violation of MAP 21. And that creates a situation where they, as you said, you might not find out this until a crash happens or something much later.
Right, right. So this is, talking about the due diligence when we look at what the customer contracts have and understanding how the company operates internally. This is one of those issues. Of course, then we're going to look at the contract. A lot of these contracts have a no assignment provision. So you have to look at, okay, if we acquire the company, that is the actual stock of the company, are we going to be violating that issue of non-assignment, or is there going to be a provision in our contracts with our customers that says if we get acquired by new owners, we have to disclose that, and then the shipper has the right to terminate the contract. So, there's other hurdles you have to get through there, just assuming that you can continue to receive that business without breaching one of those provisions in the contracts.
You might not know this, but that's the same way with insurance contracts. Because you have to get permission of the insurance carriers you have a contract with to allow a sale like that. So some of you who are listening might be familiar with that concept too, if you had sold or merged or discussed selling and merging.
Yeah, and that's a great point, Tommy. I mean, whether it's a shipper contract or an insurance contract that has those provisions in terms of if there is an acquisition or change of ownership over a certain percentage. I mean, we see it in financial documents. Banks don't want to loan money to a company where all of a sudden 75% or even 25% of the company is going to be taken over by new owners. So you have to be really careful there that you're not inadvertently causing a breach of those contracts, which give either parties rights to terminate the contract or declare them in default.
And that's the point that has some value of buying is if you want to expand your business, one way you can do it is through acquisitions. And one way a motor carrier can do it is acquiring other people's customers and keep that relationship. But as you just point out, sometimes that's not as easy to transitionalize as other ways would. And that would be the thing that you need to think about. That's why I brought that up.
Right, right. No, and that's a great point before we get to the next slide. Just, the continuity and how you continue that relationship is one that, a lot of times this is very personal to the individual owner that's had the long-standing business relationship with that customer, and that person becomes a key person. And it's critical to keep them involved in the operations. So there's that continuity of the relationship, even if the company comes under new management. And then eventually until the point that the customer gets comfortable that knowing that the same business model is flowing through to them, and that operations haven't changed. It's the same customer service. So, but yes, so that's an important point to note. Okay, cargo claims. So I brought this slide up in particular because we have issues where brokers, if you're looking, let's say, to acquire a broker, that are they ultimately going to get tagged with potential motor carrier liability and these other risk exposures that you would say, well, brokers are not liable for cargo claims. They're not even mentioned in the Carmack Amendment. Really the only thing a broker can be liable for is what they contractually agree to. And this was a good case that came out in 2019. It just kind of highlights some of the considerations that we look at, for example, when doing the due diligence of a potential acquisition, which is the same issues that the court in this particular case, Tierg versus C.H. Robinson, looked at in New Jersey. And they looked at the testimony of the parties and identifying whether C.H. Robinson would be held responsible for the cargo loss and damage claim in that case, which was spoiled chocolate liqueurs. And the court said, we're looking at the invoices and we're seeing charges for line haul. You're holding yourself out to the customer as the seamless service. We can't identify anything in your operational documents where you say you're a broker, and those issues, you want to be able to understand if you're acquiring this company, and whether it's a broker or motor carrier, are you holding yourself out as something other than what you are? And in this case, unfortunately, the court said, all right, C.H. Robinson, we can't find anything to the contrary that you really distinguished yourself as a broker arranging the transportation of property. So we're gonna hold you liable for the cargo loss and damage claim.
Wow. Well, if it wasn't for Robinson, we wouldn't have a lot of cases.
Well, that's so true. I appreciate their zealous advocacy, because they are creating quite a bit of case law.
Well, this is where, and I have never studied this case, and I have not studied C.H. Robinson. I'm just going for public this viewing and seeing the kind of stuff. But when you overstep what you're doing beyond what you say you're doing, then you could create a problem.
Well, yeah. So in this, when this case first came out, it was there's a lot of discussion of, okay, what internally, what kind of record keeping are we doing? How are our personnel interacting with our customers? And it's it's the first of the year, Tommy. I always say now's a great time to look at your contracts. Now's a great time to look at your forms, even if you're not looking to sell your company, just to make sure the affairs of your home are in order.
Well, we're going to do something, and nobody knows it yet. But Rob Mosley and we're going to put a program to do a contractual wording discussion in Charlotte. And then the last part of July, first part of August, we're putting that together. But all this comes into that area, and I'm sure Rob and how we would work in that part, because he's going to bring that. But this is a good point. Contracts become very important in your everyday life, but also with the sales and mergers.
Yes, absolutely. So these, I'm just kind of putting a different spin on these cases, just to consider them from a merger and acquisition perspective.
Right.
AMG Resources versus Worcester Motorways. In fact, there was a recent update to this particular case that just came out on January 9th, 2020. But this court, looked at also whether a carrier should or a broker should be liable for a cargo loss and damage claim. And in this particular case, the broker arranged for a shipment of copper to be transported. And the question was whether the broker assumed the responsibility of the non-delivery of the cargo. And ultimately in this case, the court went back and forth and said, okay, well, there was a affiliated motor carrier associated with this company, and it looked at, and the reason why I bring this up is, was there so much similarities between the broker and the motor carrier that they ultimately became one entity? And should the court hold them liable, the motor carrier liable, for the cargo loss and damage claim? Ultimately, the court came on the side of the broker and said, we're not going to hold you liable, and also found that there wasn't so many similarities between the broker and the motor carrier that they were going to basically find them alter egos of one another. But I bring that up because when you look at a potential company that you're going to acquire, especially one that has both a brokerage operation and a motor carrier operation, or other different lines of business, you want to see what are they doing to create walls between the companies, because in an alter ego claim, you're going to be looking at, was there some intent to commit fraud or avoid creditors, but were you also adhering to your due diligence? So if you're a corporation, did you hold your annual meeting minutes or your annual meetings? Did you record those in minutes? Did you issue the appropriate waivers of notice of meetings for directors and shareholders? And so have you gone through your corporate book? Have you done your due diligence to say that, okay, we are a corporation, here's how we operate, we've set the parameters on how we operate in our bylaws. We follow our bylaws because these are really important things to look at in an acquisition of a company, that that particular entity is adhered to its due diligence and that they've created separation between their operations such that one is not just the carbon copy of the other. Or a big one that comes up is that one company is paying for the cost and expense of the other company, which could be sharing employees. So you have to, consider the consequences of a company that has not done a good job with their record keeping on their corporate books, or they've not done a good job on their corporate structure, that there's a risk that one could ultimately be held liable for the other. And we're going to get to that here in a second.
Okay, but what you're saying is follow the money. Go ahead.
Yeah, always follow the money.
Right.
And make sure you're working with a good CPA too, that's looking over the financials of the business, so that you're not running into any issues there, where company assets get used for the benefit of the person or the owners. And so I'm going to run through some just other quick considerations here with contractual issues. I mean, we've touched on this with respect to customer contracts, financial contracts, insurance contracts, but there's also, the risk that if you're acquiring a company, that they've waived certain rights and remedies under Title 49. Which, for example, motor carriers can do pursuant to this provision we have here, 49 USC 14101B. And even though this language in this particular statute says it refers to shippers and motor carriers, oftentimes we see that same waiver language in broker motor carrier contracts. And that's, following the logic that the broker is really the shipper's agent, and can therefore require a motor carrier to waive their rights under Title 49, which would be things like the Carmack Amendment.
Yeah, that's the Carmack Amendment. Yeah, for you who don't know that buzz card, that's the Carmack Amendment, which limits the motor carrier's liability in a lot of cases for consequential damages and things like that.
Mm-hmm. Yeah, exactly. Also, overpayment, underpayment of freight charges, certain timing provisions under Title 49. There's just a gamut of a presentation in of itself for what rights and remedies a motor carrier company has under 49 USC 14101B. So you want to look at, and keep in mind that there may be things in a contract that you would think a motor carrier otherwise have because they're registered under the Federal Motor Carrier Safety Administration and they're subject to the Department of Transportation's jurisdiction. Doesn't mean that they haven't otherwise waived those rights. Those, of course, which are waivable. We're not talking about, obviously, the registration requirements and insurance requirements and safety requirements that a motor carrier is required to adhere to, and those obviously are not waivable. So there are, talking about just briefly, Tommy, you mentioned C.H. Robinson and some of the cases that have come down the pipeline thanks to many of their litigation efforts. We've seen now the Federal Aviation Administration Authorization Act, or the F4A Act, come into play as a way of saving brokers, even motor carriers, from state laws that affect rates, routes, and pricing. So, I mean, as a side note, we've seen that most recently with this
AB5 cases out of
exactly.
California. Yeah, this
Exactly.
is where you have followed California and all the upheaval about California saying you can no longer be an independent contractor based on the ABC rule. So far the judges have put off is the enforcement of that because of the F4A, which says that the state cannot make rules that impede interstate commerce as far as rates and services. And so far, the courts in California, or the appellate courts, or the courts, what level of courts they're at right now in California, have upheld and have put on hold the AB 5 cases that we have here and said, no, you can't enforce it because of this F4A, for just to tie this back into something they've heard in the news lately.
Yeah, exactly. That's exactly right. So it's a really powerful piece of legislation. If you get a chance to read the opinion that came out from the judge, I think it's, a really well-written opinion, and it kind of forecasts at least, where the judge's mindset is at. Of course, in a preliminary injunction, the California Trucking Association has to show that there's a substantial likelihood that they're going to prevail on the merits, which the court has found up to this point. So we'll follow that, but bringing it and tying it back to the issues with potential acquisition of companies, it's something to consider in terms of a savings, if you will, of a broker shouldn't be liable for a negligent hiring claim, or a negligent claim in a cargo liability context. So when you're evaluating, for example, your potential risk exposures in pending or threatened litigation, you want to at least be aware of what the defenses are, or that could be mounted by the assigned defense counsel. So even though a case may look like it's pretty significant risk exposure, you want to have an insight of what it is that your defense counsel is considering mounting as a defense. And this was just a particular case that I highlighted, where the court did find that, yes, the F4A is going to preempt the state common law claims that were brought against the particular broker that was arranged to transport a shipment of pipelines in this case. But I won't go into too much detail. Suffice to say, it is a tool out there, and something our audience should be aware of as a discussion point in a future acquisition. And we'll see, what evolves with further legislation with the F4A, as well as case law, where it has been used, for example, even by brokers, to say that if brokers are going to be held liable for wrongful death claims, that's an invasion and in violation of the F4A Act. And just to kind of wind down and wrap up the presentation, of course, taking a step back and looking at what is it that you're acquiring, and are you acquiring a company with the right structure, or are you going to need to make some adjustments to the structure in order to have a successful operation and try to put yourself in the best position possible to mitigate claims? So is brokerage separate from trucking? That's a key consideration. If you're looking to acquire a trucking company, let's say, or a company that has trucking is associated with it, with other manufacturing, which we see a lot, are you separating your shipping from your manufacturing? And there's a host of other considerations that come into play with respect to corporate restructuring, and I want to go into that detail, but the strategy may be, if you're acquiring a trucking company and you're actually acquiring the whole corporation itself, that you as an individual don't want to be the one to personally acquire that company. You want to set up a parent company or a holding company that's going to be the entity that actually acquires that operation. So that can give the individual owner some further insulation from potential liability exposure. So don't just assume that the individual is the best person to buy those assets or to buy that company. There may be a better way to mitigate your risk of loss.
Bridgette, this is a lot of legal stuff, and I know a lot of people are hearing this and say, what's it mean to me? Well, it's going to mean to you, because I'm seeing more and more motor carriers saying, I need to buy this, I need to buy it for these reasons, I need to worry about because of a case to start over again. And so we're hearing more and more of this stuff, and this is why it's important for us as agents to understand these buzzwords and these things you need to look at. There's probably more detail here than any agent would want to give anybody, but this last slide showing your address and all, where you at least can talk them through it and give them some advice and let them have some heads up how to do this. But we're hearing more and more to that. By the way, the last comment you made about keeping assets separately and not doing individual, Bridgette and I are working on a program at the annual conference again in October this year to talk about how to avoid the nuclear verdicts, how to stay in business by making sure you do divide assets up. So I look forward to working with you in the future on that, Bridgette. Thank you for your time. We always appreciate it. We appreciate your firm. Give everybody, your husband, everybody there our best, and we'll look forward to hearing from you more later. Thank you very much.
Tommy. Always a pleasure. Thank you so much for having me.